Good morning and welcome to Real Estate Know-How with Lynaae. Hi, I'm Lynaae with Forbes Realty Group, broker and owner. And today our guest is Legal Self-Help. And we have Kristine Lowe, our paralegal here. We're going to touch a little bit about her background and about the company background, and then give some advice and information on what they do and how they can help you. And we're going to share a few stories of how you guys have already helped me. So say hello, Kristine.
Good morning, everybody. I'm Kristine Lowe with Legal Self-Help. We want to be your full-service alternative to an attorney.
That's right. And one of the things that, tell us a little bit about your background as a paralegal.
Okay. Well, I've lived in Vegas since 1991. I started working with with Legal Self-Help then. I went to paralegal school back in Chicago. I have a paralegal certificate, and I've been working with Legal Self-Help ever since I got here. So my background is years and years and years of experience of helping people. So.
Okay. And have you ever worked for an attorney's office?
I did briefly work for an attorney's office when I moved here, and I discovered there that that I did I did all the paperwork, and the attorneys did the talking and
the advising.
Yeah, basically. So it was then that I learned that, as a matter of fact, I worked for a small law firm. I won't mention any names.
That's
and
okay.
The associate was a crazy lady, and she really didn't know what she was doing. She got fired, and then they asked me back because I knew
what was going on.
Yeah, so.
Well, we were going to make a distinction today a little bit here, too. Paralegals are not allowed to give advice. However, they're allowed to explain.
Correct.
Okay, and I always compare that to my apple pie. I'm from Wenatchee, so apple capital of the world, and we've got the Granny Smith that you want to explain how it's a green apple, it's kind of sour, and then we've got that golden delicious. And then I have to ask you a question: which one, after I've explained both of these apples, which one would you eat, or which one would you put in the pie? And if you can actually make that distinction, then you're not advising the client which one would go in the pie.
Right.
But if I explained it correctly, we would know that the Granny Smith goes in the pie. Right. Because you're going to add sugar and all those good things to make it.
Yeah, we're all about educating and empowering people and letting them understand their options, and then they choose. Yes.
And what I really enjoyed is how I found you is that I reached out. I had a paralegal that was working with me for a while, and then one day he just kind of like blew up on me, and I'm like going, oh my gosh, I need a paralegal. And you guys came in and saved the day.
Yay.
I had you help me with a client that didn't have a lot of money in the house. It was an estate sale. We had a will. We had all of the documentation. We had the death certificate. And you guys came through and helped my client prepare the paperwork. And not only prepare the paperwork, but you were able to represent her because she was out of state. Is that correct?
Well, we didn't represent her. We prepared the paperwork. She was actually representing herself.
Okay.
But we prepared it and filed it with the court for her. So.
And what was it that there was a document, though, that an affidavit she had to do because she wasn't here, that you did on her behalf?
Well, we did a petition.
That's exactly what I was talking about. So we did a petition for a stay, or
a petition to set aside a small estate.
Okay, small estate. And it worked out really good because I just closed that estate sale about 2 weeks ago.
Okay.
And we could have closed a lot sooner, but we ran into a few difficulties with the previous.
If the estate is under $150,000, then it can be set aside with a relatively quick probate process. It's the lowest form of probate, called a petition to set aside a small estate. Yeah.
Right. And just walking through the door of the attorney's office, we're talking $5,000.
Probably. Yeah.
Yeah. I mean, we priced it out. Do you need to get seated there?
No, I'm just shuffling.
Okay. But that was one of the things that we ran into, is that my client did shop around a little bit, and in the end we wound up going with you guys because it was like 3 times less than what the attorneys wanted to charge us. And so we were able to go through and do this. That's actually pretty good. When people know what they want, you could explain the documents, prepare the documents, and then file the documents on behalf of the client.
Right. We are a full service. A lot of people don't understand exactly how an independent paralegal works because they're confused we don't represent them. We're not attorneys. We can't give legal advice, but we can prepare the documents, we can file it, we can do everything procedurally that they need to do to get it done. So,
And isn't it a paralegal that does most of this for an attorney
yes,
anyway?
it is. Yeah, that's what I was talking about in that example that I was talking about where I first worked. Yeah, they're the power behind the throne, if you will. They're the ones who actually prepare the documents, proofread them, submit them for filing, communicate with the courts if there's a problem. And luckily on that one, that one went really fast and there were no
Well,
problems.
I think a lot of it was because we were prepared. We had the death certificate, we had the will, we had the addendum, or the additional document, because we found that actually in our files. Before we were cleaning out the files,
Right.
we actually found that
Yeah,
addendum.
the attorney had done a kind of a weird thing. They had made they referred to an attached personal property list, and when I looked at the will, I'm like, oh no, but Lynaae had it, so it was okay.
But you see, that helped a lot because when the estate came in from California, they basically handed us the file and said, help us.
Right.
And, I'm not an attorney either. As a matter of fact, as a licensed real estate agent, I'm not allowed to advise my client how to take vesting or how to do this or how to do that. However, having people like yourself available that can do what I can
Right.
do, and that is explain things.
Joint tenancy, explain tenants in common,
And
explain
community
all
property
all
and community
those-
property with the rights of survivorship
Right.
and how that all works.
Right.
And you guys do simple trusts too, correct?
We do living trusts. Yeah, actually we do living trusts, and we also do other forms of trust too. That's why we have people come in to try to find out what they have and find out what their wishes are, and then we can educate them about the different kinds of trusts. And yes, the most common form is a living trust, and our living trust package includes powers of attorney, healthcare power of attorney. It's a comprehensive package. It takes care of everything that they need to take care of in their estate planning. So, and we also do the deed to transfer. We do the deed to transfer the real property into the trust, so
Which
that
a
the
lot of
trust is
attorneys actually
funded.
drop that
Yeah,
ball.
yeah. I just had a client come in to me that had had an attorney do a living trust, which no problem. And I think they did, again, I won't mention any names, but they had paid, I think, $1,000. We charged $650, but which is relatively low cost for an attorney to do a living trust. But she owned 3 real properties. They had only gotten 2 of them transferred into the trust. And she came, and my client came to me. It was her daughter. Her mother was just diagnosed with brain cancer, didn't have very long to live.
And we're like, oh my gosh, we got to get
Yeah.
this all together.
Yeah, and
So what about life insurance? Do you help people get their life insurance into those programs, into those
well,
trusts?
life insurance doesn't have to go into the trust necessarily. If it's already got a beneficiary designated, it's not necessarily a probatable asset, so it doesn't have to be transferred. Now, you can transfer it. Let's say if you want your life insurance policy to be distributed to
Several people.
60% to this person and 40% to that person, then you would transfer it into the trust and make the trust the owner, and then the successor trustee's responsibility would be to disperse it in
Okay.
accordance with your wishes. So.
Yeah, because I've got 3 life insurance policies, and I've had a real tough time getting that information together to get it filed with the trust, because then they send me all the documentation, and I've got to get it notarized. I
Right.
got to prove, and it's just like, really?
Right. Whenever there's money involved, there's always lots of technical stuff to take care of. And we do a lot of hand-holding. We do a lot of, not necessarily things that we make money on, but somebody has a question about how to, their parent has died and they want to try to find out how to get the life insurance, and we can give them some information and guidance on that.
Okay. And you talked about, power of attorney. Power of attorney would be doing what?
Well,
For
there's
them in a trust.
Yeah, in a trust, actually we do 2 different powers of attorneys. We do the general power of attorney. The general power of attorney is a document that gives them, only is effective once the trustor, once the person who establishes the trust is disabled. So in other words, once they sign it, they don't automatically hand control of the checkbook over to their son or daughter, or whoever they've given power of attorney. It's only if they're disabled. And so the general power of attorney allows them, like let's say somebody had a stroke and they were no longer able to handle their finances. Now they're able to step in and handle the financial things for their parent.
I actually had a client that had an accident and his signing arm was
Oh,
basically disabled.
exactly.
And so he asked his friend, and he was there the entire time, but he asked his friend to sign on behalf of him using a power of an attorney.
Right.
And we were able to have that drawn up by the title
good.
company.
Yeah.
So that was kind of a unique situation.
And it's important to get your power of attorney done before you break your arm.
Yeah, we did have a little difficulty
yeah,
there.
because or with parents before they have that stroke, because then they're not able to sign and they can't give you the power of attorney. The other kind of power of attorney that's in the trust is a healthcare power of attorney, and the healthcare power of attorney, they make decisions ahead of time as far as what healthcare measures they want to be taken, what measures they want to be taken to extend their life, or what kind of treatment that they want, and they put into writing ahead of time what those decisions are, so that their agent, the person that they give power of attorney to,
knows.
only has to enforce those wishes. They don't have to make the decision.
Got it.
But again, if the
Like a
person,
DRN
Yeah.
or whatever, they say, I don't want, life support done at this point.
Right.
And that power of attorney gives, let's say, the daughter or the son the right to enforce that, is what you're saying?
yes, correct.
Okay.
Yeah.
So that sounds like a great idea.
It's important to do it ahead of time because things happen. I don't know how
Right.
many times I've had people call over the years, my mother's in the hospital, she's in a coma, I need to get her power of attorney. Well, at that point, it's too late for them
Yeah.
to sign it. So
And this is where a trust can actually be very helpful too, because the trust keeps us out of probate. Am I correct?
Yeah.
If we've gotten everything moved into the trust, such as the personal property, the real property like a house or the land, then that gives the kids the ability, or the survivors, the ability to take care of the asset outside of probate.
that's correct. That's the major advantage of a living trust, is that it avoids probate. So in the example of a house, for example, once the person who established the trust dies, then the successor trustee just needs to do a new deed where they transfer the property from the dead person to them as the trustee of the trust. So it's, as far as cost, I mean, to do a deed, we charge $75 plus the recording fee, which is another $25. So compare that with having to go through a probate. Again, the lowest form of probate is a set-aside estate, and we charge about $1,200 to do that. So
Yeah, compare the two. Well, I've always told people, you can either pay the attorney now, or you can pay the attorney later.
Right.
You can pay a lot less doing it now, and then you put your family through a lot less stress too, because as a survivor trustee, all that can be done at the time of closing out the sale, if you sell the property, let's say. Because it's already in the trust. So you're just the trustee that's going to activate or do the trust that moves it over
Right,
to the
they're
purchaser.
just in charge of putting into effect whatever the dispositive wishes of the person was.
yeah.
Which dispositive means whatever they said about how they want the property to be distributed.
Right. Well, very good. Okay, well, we're coming up to our first break, and we're
Okay.
going to we're going to touch on some great stories and talk about a few other things that I know that the Legal Self-Help can do. Legal Self-Help Document Preparation Service, established in 1990. We have in our studio today Kristine Lowe, our paralegal. So Lynaae, let's see, how do we put this? Real Estate Know-How with Lynaae, and we'll see you around the bend. And good morning and welcome back to Real Estate Know-How with Lynaae. Hi, I am Lynaae with Forbes Realty Group. Just opened our office in January. Loving the ability to be the broker, be the owner, be the decision maker. It's awesome, actually. So,
Yeah.
And last week we had on our radio show, we had Legal Shield. There's times when you need to reach out to an attorney. And wouldn't it be great if you had the ability to do that and not have to pay a $250 fee just to sit down and talk to the attorney? Well, I got to do that yesterday with a file that I've been dealing with, and the agent took it upon themselves to state what the due diligence was for the borrower or the buyer. And in this case, I was able to have the attorney step in and say, no, according to the contract, and this is the contract that was been put together by the Greater Las Vegas Real Estate Board, Association of Realtors, that stated that upon receipt of any disclosures, the buyer had a full, and in this case in the contract it said 10 days of due diligence, a full 10 calendar days to review that document. And the agent made the mistake of writing in an email telling us that the buyer only had 2 days. And we were able to call and say, you know what, you're not an attorney. You can't make that decision. And the attorney on the file stated that we have to follow the contract. And so we have to be really careful as real estate agents giving advice. Again, today I have in the studio with us legal self-help. They're document preparation services. The one thing that's changed since the last round up at Carson City is they're no longer able to prepare bankruptcy documents, because bankruptcy is such a complicated procedure to go through, and everything that's needed it's necessary for them to actually have an attorney in place. But for things like what we did recently in a probate with assets less than $150,000, it was just not. It was not an effective way to use the assets of the estate to pay an attorney to just get a set aside and allow who was in the will, the person who was given the property, to lose out on that. And basically what was really cool is that she walked away with $53,000.
Yay! All right.
That would have been, hard pressed with an attorney involved. We would have probably been talking $30,000 by the time they got done, doing their court and their procedures and this, all these things. It was just great not to have to go through all that, right?
It worked out really well for her, elderly lady, and and we had a few delays because she had to keep going to funerals and all of her friends were passing. So I was really actually happy, and she told me she was going to go and take a cruise. Oh, excellent.
And then she was going to take some of the money after this and go give to some of her favorite charities. So. But one of the things that you and I were talking about during the break was one of your things that you do with divorces for women. Mm-hmm. Tell us a little bit about that.
We have a DBA, Women's Divorce Clinic. We help people represent themselves. So I do a lot of uncontested divorces. There's a procedure for divorce called a joint petition divorce by summary procedure, where if both parties can agree, at least one of them lives in Nevada, and they've agreed on custody, they've agreed on child support, they've agreed on any obligation for spousal support. They've agreed on all the issues that need to be decided. If they can agree to it, we can do papers, and they both sign in front of a notary. We're notaries. And then we just file it with the courts, and the judge grants a divorce as soon as possible without a hearing. So
what we've done is we've basically taken the attorney out of there that usually is looking to make money by causing an argument.
Right.
And it is their job to help the divorcees or the people that are going through divorces, but sometimes they can probably add a little fuel to
They try to add maybe sometimes in a more adversarial situation to make it drag out. And but I also handle contested divorces. I mean, the other way, if they can't agree, then we file a complaint for divorce. Mm-hmm. And the complaint says I file it on their behalf. They tell me what they want. And then we put that into writing. We sign it. The other person has to be served. If they contest it, that doesn't mean I can't continue to help them. However, if their spouse has gone out and gotten an attorney, they may want to, at that point, transfer the case or get an attorney to help them, but they don't have to. A lot of people flat out can't afford an attorney.
And I had on one of my shows just in the recent past a gal named Nancy Gabriel. She is with Mediation Around the Table, and one of the things that she talked about, sometimes it's not about the splitting of the property or the assets or whatever. It's talking about feelings and getting past some of the anger and the resentment, and especially when we've gotten to this point in people's divorce and we've got a house involved and we got children involved and whatever. And I know that as an agent that's represented people who have, agreed to sell their property, right. Wow, sometimes you can cut the air with a knife. Mm-hmm.
Yeah.
But they're having people like yourself and Nancy involved. Right. It can actually reduce the amount of cost.
And I always tell people, I mean, if they've got a sister, a daughter, anybody going through a divorce, you have to start somewhere. Mm-hmm. And a good place to start is a conversation with somebody like me who's been through thousands of divorces, and I can explain to them procedurally how a divorce works.
And that helps a lot. Mm-hmm. People need sometimes to just be told about it, and they may not remember everything the first time you tell them. But eventually there's going to be that little spark. Then all of a sudden one day they go, oh, I got it. And it's like that quantum leap.
Yeah, I've seen amazing transformations because I see people come in and they're all, you're right, they're all consumed with the emotional side of it. And after I explain to them the components of a divorce and how it actually works, then they get it. They're like, okay, this part is just about the business end of it. And they put their feelings aside and they're able to make a lot more progress in the divorce process.
And I bet you could use somebody like Nancy in your service.
Yeah, as a matter of fact, I just heard about her. I was going to contact her and reach out to her and do some networking.
Well, great.
with her,
I'll introduce you because I think she would be a great asset to your what you guys do. Because again, people forget. There's a difference between residential real estate and commercial real estate. Commercial, there's no emotions. You make an offer, you base it on your numbers, and you leave the emotional part out. However, I've got this saying. And that is I've never sold a house. Why? Because a house sells itself. And what usually happens is when people walk into a home, they either love it or they like it or they don't. It has nothing to do with me as a real estate agent. I cannot sell that.
Right, and I can't sell divorces. So.
Exactly. So sometimes it's just laying out the groundwork, and sometimes I don't like to overwhelm my clients, so I give them the basics, like I call it the skeleton to start with, because I don't like, there's more to it. When we get to the hand, we've got all these different bones. We don't want to get that detailed with them. Sometimes that's why we're the expert.
Right.
We want to just say, hey, this is what we need. This is why we need it. Can you give it to me?
Yeah. People come in for a divorce consultation. I have to hear. I used to have a favorite story of the week, like who slept with who. My favorite story. This is funny. So people come in and they always want to tell me why they're getting divorced. Well, really, that doesn't matter. The grounds for divorce in Nevada per statute are incompatibility or living separate apart for a year or more, or either one or both. And I had a client come in, and I talked to him for maybe 20 minutes, and he kept on saying, don't you need to know why I need to get divorced? Don't you need to know why I need to get divorced? This is probably 10, 15 years ago. And finally I said, okay, go ahead and tell me. He said, because I just found out that he's a she, or she's a he.
Boy.
Yeah, so I didn't go there. And afterwards I got done, and this time we had other employees, and they're like, why didn't you try to find out how he found that out? And I'm like, I didn't want to know.
Sometimes sometimes people, if they just get it off their chest, they then can move on or make a better decision, and they just need to sometimes just have someone recognize that, and that's all he was looking for. It looks like.
Right.
Yeah. So. Sometimes when we were going through the process of housing and going through why do we need a trust, and I work a lot on getting clients to do that kind of stuff. But then when we get to that divorce, unfortunately, that's a messy situation.
Divorce and logic don't go together.
No. Common sense?
No.
No common sense?
No, not much.
A lot of emotion?
Especially when there's children involved, custody issues. I mean, I also do post-divorce work. In other words, if somebody needs to go back to court, they're having trouble with their spouse over the visitation. We have to file a motion to go back to court, and we draft, they help us draft, but we draft motions to get them back to court so they can get before a judge and have that issue resolved.
And so when someone has lost their job and there's child support and alimony, is that a really tricky thing to deal with?
Well, they need to do a motion to reduce child support, and it's actually a motion to reduce child support can be. I have a lady going to court tomorrow about that. But it can be. In that case, it's pretty much cut and dry because they have to submit their financials. They have to file a financial affidavit that says what their income is, what their assets, and the judge pretty much bases his decision on that. So, but to put that into writing, sometimes they need some hand-holding.
Right, and that brings up a question, and because I've never asked you guys this, and you may not have done it, but did you ever help people through the crisis with modifications and short sales?
Yes and no. I mean,
because that's a lot of documents. Sometimes it's just it's just like document after document after document.
Yeah.
And I had one file that had the lien holder servicer, and then like HUD or Fannie Mae or Freddie Mac's required documents. And it's like, oh my gosh, and they all repeated themselves, but they were all differently written, and you're just like, that's like overwhelming.
Yeah. We don't specifically. I mean, it's not something that we have on our back of our business card as far as something that we can do, but everything that we do is not listed on our business card. A lot of times it's something that maybe we don't do or we didn't list, but it's something that I certainly would have a lot more experience with. I know that different documents repeat themselves, so I can read through the legalese and help translate it to them. So
That's great. I really appreciate that. And one of the things too, because I'm going right now, I'm dealing with a short sale where it's an FHA and the people have gone through bankruptcy. And it's like, are you kidding me? You're requiring all their financial information after they filed bankruptcy?
oh wow.
And so now I got the bank on the phone, and the bank's they're not willing to give me the guidelines for FHA. I have to go directly to FHA and get them.
Yeah, and people don't know where to look. I mean, a lot of times it's as simple as a Google search, but even if you find it, then you don't know what you're looking at unless you know how to look for the right information. And
Well,
that
it's
comes
really
with
funny.
experience.
I've been putting that in, and it's all talking about, people who want to go back and get financed again for FHA. They're not talking about the guidelines, what's required if you want to short sell a property after you've gone through bankruptcy with an FHA loan.
Okay.
And so that's been actually quite a task. So I finally reached out to FHA myself. So we'll see how that goes.
Yeah.
Got a case number and everything.
There you go.
All right. Well, this is Lynaae. This is Real Estate Know-How with Lynaae. We're going to come up with our second break here, and we are in the studio today with Legal Self-Help. Kristine Lowe is the owner and paralegal of Legal Self-Help, and their website information is www.legal-self-help.com. Okay, we'll see you around the bend. Well, welcome back, and welcome back to Real Estate Know-How with Lynaae. And I'm Lynaae with Forbes Realty Group, broker and owner. And today in our studio, we have Legal Self-Help, Kristine Lowe. And I have her card today, and I thought what was interesting was some of the services that they offer. Family law, which we talked a little bit about divorce. We talked about marital separation.
Marital separation, yeah.
That's a really actual simple document, and we actually had to have one filed for one of my short sales.
Yeah, there's two different ways of getting a legal separation in Nevada. They can do if they can agree, and this I've done this to help people through a real estate transaction. They can do a marital separation agreement, which is a contract basically that they both have to sign in front of a notary, and that satisfies most mortgage brokers as far as, let's say, you're trying to demonstrate that the one person doesn't have the responsibility for the payment of the house, even though it's in both names.
Exactly, and that's exactly what we've had to do. We've utilized the separation document, so I'm glad to know that. And then the other thing I like is estate planning. I always am constantly talking to my clients.
I know. The mortality rate is still at 100%, and people and people just won't. They just don't want to talk about it.
Yeah, and it's funny. I just went to an event. I think you and I were at it. We were over at Palm Mortuary where Mary got up and spoke about that. And sometimes she says the hardest thing about life is getting through the hard part, because then once you get through the hard part, you can get to the other side. And that is where trusts and probate and wills come in.
And just having the conversation with your loved ones. I mean, because the fact is that you are going to die. I love it when people say, if something happens to me.
No, it's not
when.
It's when.
And, you need to talk with your daughters and sons and things about what you have and how you want it to go. Otherwise, and then put it into writing. Because otherwise, the husband dies suddenly, and all of a sudden everybody's grieving and going through all the emotions, and they haven't put into writing what happens, and that's when fights start, and
that family fights,
right? And having a will or a trust doesn't necessarily eliminate that. They're still going to fight, but at least there's something in writing that it is they can take it to court if they have to.
Well, I've always said the difference between Michael Jackson and Robin Williams. Michael Jackson did not have a trust.
Exactly.
And did you hear all the news when he died? Years of news. Okay, but Robin Williams, he recently passed, and we only heard one thing. Someone did have they did try to challenge the trust,
right?
And it got thrown out.
Yeah. Well, in our trust, for example, again, I'll go back to the basic living trust. There's a clause that says if anybody contests it, they get nothing. So there's a non-contest clause.
And basically, I think what they finally I don't know if they lost out on it, but I think that the challenge was definitely undone, because the whole point of the trust is to keep it out of the courts.
Right.
Am I correct? And I've always said, you either have all your dirty laundry out in the public, like Michael Jackson did, or you're going to keep it in a safe, quiet environment,
Right. And the other
like
thing
a trust.
the other thing about a living trust is that it's a private document. Nobody needs
It's
to
not
see it.
Exactly.
Right.
You don't have to file it with the courts. You don't have to file
As opposed
it.
to a will, when you die, your will
It's
your
made
will
public.
has to be lodged with the court, and then it's public. Yeah, it's open
public
to the
record.
public. Exactly.
And that's what a lot of you'd think after all the celebrities, with all these attorneys, the one thing that they would do is put their assets into a trust so that they're not out there showing everybody what's going on.
I don't know why people drag their feet. I mean, I think a lot of times they're afraid that they think it's too complicated, they think it's too costly, and that's again, I hammer on the free consultation. Come in and talk to us.
Yeah.
Find out what your options are.
And you might be amazed at how little
Yeah.
expense it would take to have a peace of
Right.
mind and have things done your way.
Yeah, and we even do payment plans. I think last year a lady came in to me and she had just gotten remarried. I think it was her second marriage. She owned some real property, and she had some health issues, and she knew about trusts, but she thought she couldn't afford it. And she came in to me, and they actually wanted to do a post-nuptial agreement saying that my property is my property and his property is his property.
Right.
Well, after I talked to her, I'm like, well, what you really need is a trust. And she's like, well, I can't afford it. So we made payment arrangements. And in the trust, for her new husband, we gave him a life interest in the property. In other words, he can stay in the property
As long as he's alive.
As long as we would put clauses in there saying that he has to be responsible for the bills on it and whatnot. But as long as he's
Lienable
alive,
items.
right? As long as he's alive, then he has the right to stay in the house.
And we talk about lienable items. Lienable items would be like the HOA, the sewer, the trash. And believe it or not, water is a silent lien. And the reason it's called a silent lien is because it doesn't get actually liened on the property, but the new person coming onto the property has to pay that previous bill. But we had an exception, we found out,
There's always an exception, yeah.
and that was our deceased. And so the buyer didn't have to pay that old water bill. The water company waived it.
Good.
So there are exceptions to all rules, but during this, when we had the downturn through 2008 to 2011, when we saw the greatest amount of properties go on the market for foreclosure and short sales and things like that, one of the things people failed to do is keep up the basics things, and because they won't turn off the water on you here in Las Vegas. You have to actually call to have it turned off, or there's a pipe burst or something that would cause the water company to turn it off, but they won't turn it off. Okay, so if someone doesn't pay their bill, they just keep running the water. They allow that.
They just keep on running up the bill.
Well, of course, they keep running up the bill and get late fees, etc. But the bottom line is unlike the power company actually comes in and turns off the power after several notices. And in some cases, you can go to them and plead your case, and they may leave it on if a payment plan's done, but water is not turned off. Sewer's not turned off, and that's a lienable item. Trash is not turned off, that's a lienable item. And the HOA, which we've gone through, actually had Alexis Brown on the show where we talked about the HOA liens that were happening and how they found the loophole that undid the first lien holder's position because they became first lien, or the super lien as they called it. However, in the last session in Carson City, that got tightened up a little bit. And one of the first things I noticed when that happened is immediately my mortgage company filed on the title report, or we call the recorder's office, a document that requires the HOA to notify them if I do fail to pay my HOA.
Okay.
So then the lien holder now can come in and take and pay those before they get so astronomically out of this world. Because I had a couple, one it was over $18,000, and they tried to foreclose, and I was able to get the lien holder to come in and pay that.
Wow.
So that they wouldn't get foreclosed on, because the lien holder would lose their position. And I was able to bring to their point, this is a Freddie Mac property. You really don't want to be messing with them doing this, not paying this, and putting them through unnecessary paperwork. So it's really, really helpful to find places like this. Now, when we were talking about real estate, I love this. You've got all deeds of trust, promissory notes, and offers and acceptance. Okay, obviously, I do a lot of real estate.
Obviously.
And I loved it when I went in with a client on a mediation, and one of the requirements of mediation is that the lien holder had to describe every document. So if it was a deed of trust, they had to do a certificate of deed of trust.
Oh, wow.
Well, when my client went in there, because I had educated her the difference between a deed and a deed of trust,
Okay.
they had put on the certificate deed.
Oh, no.
Now, you and I know that the
Not the same
deed
thing, right?
conveys the property. So if I'm going to sell you my house, I'm going to do a deed, which is a sale of the property. And that deed now allows me to convey to you to be the new owner.
Right.
However, the deed of trust is actually putting a cloud on the title, putting a lien on the property. Totally two different things, right?
You lend somebody money for the property, and
Well, so what was really great was that they won their mediation because of the fact that
they screwed it up.
Well, yeah, call it a clerical error, call it not being knowledgeable, but in our profession, you and I, we need to understand these documents.
I had a similar case, and I had a lady come in, and she wanted to sell her house to her son. And the house at the time was owned by she and her late husband. So we tried doing an affidavit of terminating joint tenancy, because
yes, and I've seen that done.
And an affidavit terminating joint tenancy is if your spouse dies and you hold the property as joint tenants, you need to have prepared and record an affidavit of terminating joint tenancy, and that just simply takes the title of the house from one person, from the husband
From the
and
deceased.
wife, right, or whoever the joint tenants are,
Right.
to just
the
the one
survivor.
person, right. Well, they had done a deed. They had done a deed, and I didn't look at the deed but then it came back. The affidavit of joint tenancy came back, and come to look up the deed. On the deed, they had written it, and they had done their own deed. Okay, and they put just Mary and Joseph Smith,
And they
didn't put
designate
husband and wife as
no
joint
vesting.
tenants. So then she ended up doing a set aside to get her half, to get her late husband's half of it, and that happens a lot. People are, there's all sorts of there's places like Nevada Legal Forms. There's everything on the internet, and so people try to do their own documents, but unless you understand the terminology, so that's a perfect example of why a lot of times it's better to go to a paralegal, less cost, and
Less mistakes.
and less mistakes and less
And let's
headaches.
talk about that for a minute. One of the things I always love to talk about, this little piece of the vesting is a really important thing. And in 2001, one of the things that the vesting was changed was to add community property with rights to survivorship. And the reason why that was happening is because a lot of people were being advised and not correctly to go joint tenants. Joint tenants was never intended for the married couple. It was intended for the father and the son who wanted to buy a piece of land together, two unmarried individuals who wanted to buy a piece of land or a piece of property, and they had already agreed that whoever died, that would be their property in the end. They called the joint tenants the poor man's will.
Okay.
Because it kept you out of probate court.
Right.
But the biggest problem that comes from that is a tax implication for the married couple. So under joint tenants, when that one passes, the $500,000 that's given to the married couple does not survive that, whereas under community property with rights to survivorship, it does.
Okay.
So that means that my husband dies, I still get to claim the entire $500,000 if we're listed as community property with rights to survivorship.
Right.
However, under the joint tenants, I'm technically liable for half of the taxes on his half of the $250. So do you see how important it is that you talk to people who know what they're talking about? Okay, so we're talking about different documents and about different things and how they work. It's so important to know that you have knowledgeable people, resources. I call you my resource.
There you go.
Nancy's my resource. Legal Shield's my resource. I've got Alexis Brown, who's my resource for going through the HOA issues and stuff like that. It's just so important that you reach out to your community and your network.
And if somebody calls us and it's something that we don't handle, we don't handle immigration, but I have people who I can refer them to. So
you have a referral network.
Yeah, because I've been in the community since 1991, so I know people to send people to.
And we like to always refer to people that we know, like, and trust.
Yes, exactly.
Okay, and you obviously know, like, and trust this person that you're referring business to, because I bet they refer business back to you as well.
Yes, yeah.
Okay. This is Real Estate Know-How with Lynaae. In the studio today is my guest with Legal Self-Help, Kristine Lowe, and we will see you around the bend. Good morning. Welcome back to Real Estate Know-How with Lynaae. Hi, I'm Lynaae with Forbes Realty Group here in Las Vegas. Opened my office in January. I'm so proud to be a member of the Realtor Board. Today in our studio we have Legal Self-Help document preparation service, owner and paralegal Kristine Lowe. And what we're going to do is touch a little bit about just businesses and corporations. I guess one of the big things that came out of Carson City last time was is that they started charging more for corporations.
Yeah, they increased the business license fee from $200 to $500 for corporations.
Yeah.
And LLC stayed at $200.
And I'm so lucky I'm an LLC.
Yeah.
So what the great thing is and this was something that your office helped me with, when I went from being an individual LLC, because I was Lynaae Forbes LLC, and the state gave me the ability to open my office, we were able to flip my LLC to my Forbes Realty Group LLC. And you helped me with that. That was actually quite a simple process.
It was just a matter of filling out some forms and sending them up to Carson City.
Yeah, with some money.
Yeah, with some money, yeah. And we changed your resident agent.
Yeah, we made you my resident agent.
Yeah.
A lot less expensive than going through an attorney who, by the way, they're just sitting there collecting my fee,
yeah,
right?
the resident agent's only purpose, a resident agent is somebody that if you wanted to sue the corporation, it's who you serve the papers to. So that's all it is.
Ah, interesting. Well, I have to keep that in mind because I know that I'm working on a small claims as well. So that's interesting because it is an LLC that I'm doing this against. So that'll be an interesting outcome.
Yeah. We're working on that.
Okay. So one of the things that we've been doing today is we've been talking about how inexpensive it would be if you know what you want. Okay, so you go in and you go, hey, I want to get a divorce. Me and my husband, we're in agreement of how we're going to split the assets, how we're going to take care of the child, how we're going to pay alimony. You can help prepare those documents and keep an attorney out of that.
Right. Well, even if they know what they want, but the other person isn't in agreement, we can,
But that's one of the first steps. And then we've talked about the fact that if they didn't, and then we talked about Nancy being a mediator that may be able to help, because most of the time what they're asking for may not have to do anything with money. It's all about the emotion.
Right.
You know, they got stuck on a resentment and somebody didn't acknowledge that resentment, and then they go, until that is acknowledged, I can't get past it.
Yeah.
And you having the ability to recognize that is probably going to be huge.
Yeah.
And again, cost effective.
Very cost effective as opposed to an attorney. Yeah.
Yeah, because attorneys tend to be adversarial. That's how they make their money, right?
Right.
And you know, if you don't have a lot of assets, that's just not the smart way to go.
Right. And actually, there's a statistic that from the family law court, 70% of the people going through family court right now are self-representing. So it's not like an unusual thing. The difference is, are they self-representing totally on their own, or are they using a paralegal who knows how to do the documents and who knows the rules of civil procedure and can guide them through the process?
And there's where the silver lining lies.
Yes, exactly.
Is the procedure and like, I'm not going to be an expert in this. I'm probably going to go through it once, but you've been through it a number of times in the years that you've been a paralegal. So it's like you kind of know the process, and that's what we're really paying you to do, is to know the process and explain the document, what I need to put in that space.
And to troubleshoot, yeah.
Yeah. Okay, well, good. And then I get, properties that were like I had this estate sale, and you guys were able to help us do the probate. And again, that was just a matter of process.
Okay. And we don't just do small estates. We can handle we do probates of all levels.
Okay.
So, a probate is a good example of something that, unless there's fighting over the will, if let's say the estate is worth $200,000, well, that's a higher level of probate. There's more steps involved. There's more.
But if all the parties are in agreement, then you could actually save them money by just helping them through the process with the paperwork.
Exactly.
That's what we want to hear.
Yeah.
And I deal with buyers and sellers, and the first question out of most of my buyers' mouth is, well, how much is it going to cost me?
Right.
Well, what it's going to cost you is loyalty to your agent. That's it. Not money, loyalty. And I had a phone call yesterday. It was very, very interesting. The buyer wanted to see a property, and so I started asking all the right questions. And some of that question was, do you have a real estate agent? Well, yeah. And I said, so why are you talking to me? What do you mean? And I said, well, your agent represents you, but they don't get paid till they actually close
the deal. Yeah.
So are you paying them? Well, no. And I said, so are you loyal to them? They hadn't even taken them to the lender yet.
Wow.
So they had no idea what they could even purchase. And I'm like going, okay, so you're gonna fail, because you're gonna go in and look at this great big beautiful house that you're not qualified to buy, and now that's gonna be your benchmark for every house that you look at.
Oh no.
It's best to look at first, know what you can financially buy, and then look below that before you go above that. Because
So
once you go above that, you're never going to be happy.
And that goes back to, I don't know if this makes sense tying it in, but if you're going to get divorced or you're going to have a living trust prepared, or why not talk to a paralegal for a free consultation first?
There you go.
Get things explained, and then you can make decisions. But until you have enough information, you can't decide whether or not you're going to need to hire an attorney, or whether a paralegal is going to be able to help you with it. So it's all about communication. I always like to have the conversations with people.
Yeah, have that cup of coffee and go through it gently with them, and talk about things that they may not be willing to talk to, that you have to broach that. It's funny that you say that, because I just did a lease for an elderly couple, and I actually had added to the lease that if one of them passed, that the lease could be canceled.
There you go. And
they're like going, oh, can we do that? And I'm like, why wouldn't you? Do you think your spouse could handle that payment after you pass? Well, no, because Social Security and income is based on
fixed income, right?
Right, on both parties. And if that one of them goes away, they're going to lose part of that income. Do you think now they can actually make that lease payment?
Right. So they need professional people like ourselves who will, with some compassion and some.
But that's willing to go to the hard the hard place, or the place that people don't want to talk about. Like when we were over at Paul Mortuary, and Mary was talking about that fact that she helped her stepfather all the way through the process of him, and she's like, "Why did you pick me?" Because he knew she would help him.
Exactly.
And that she would be willing to go to that hard place. And she goes, what a wonderful feeling to get to the hard place, because after that, I'm now on the easy side of it.
You can relax. And
it's like at the top of the hill.
I can't tell you how many times people have come to talk to me about, whatever they've come to talk to me. They've come to talk to me about their estate. They've come to talk to me about divorce, and they leave. And now that they know the information, their shoulders are back and they're smiling, because they've been through the hard place, and now they have a glimpse of how it's going to work, and they feel better. So,
well, unfortunately, one of the things that we went through with this downturn was people were really truly putting their head in the ground and not wanting to deal with things, and then all of a sudden when it blew up, they're like, woe is me. And it's like, no, it's not woe is you. You've got people out here like myself, like Kristine, who are willing to help you through the process, especially when it comes to your real estate needs. I'd like to thank you for being with us today. We are Real Estate Know-How with Lynaae. I am Lynaae Forbes with Forbes Realty Group, and today in our studio was Kristine Lowe, owner and paralegal of Legal Self-Help. Thank you for joining us. We look forward to seeing you next Tuesday.